guys, there you are. Thanks for coming back. I am the Lincoln Lawyer. I hope you found the last video regarding Kobe Bryant's estate informative, interesting and elucidating. So today I just want to do a jump off that video and talk about control of your own assets. So the point of that video was to avoid having the state decide how your assets are distributed and who they go to. So I prefer to have control. That's just me. Some people, they want to allow the state to decide how their assets are distributed, so that's up to them. But a trust is a perfect vehicle to permit a person to control the distribution of their own assets. Generally, most people of means of significant wealth will not hold their own funds in a single account at a bank. So they may have a smaller account to fund incidentals and day-to-day expenses, but generally most of their assets are going to be held in a trust. So the way it's generally done is a trust is established by an attorney, and the owner of the trust does not actually fund it directly. So once they are paid on a certain project, which is multi-million-dollar, let's say for example they receive a sports contract fee, then those funds go directly into the trust. So the owner never actually touches that money. They never have control over it. So they're not the settlor. Okay, so they can easily become the beneficiary. And then the trustee would be a third party, like a professional trust company or a financial institution that manages trusts. Then they're going to abide by the trust agreement and make distributions in accordance with that document. So the owner of the funds never actually touches it. So let's say a actor or a singer or anyone who makes large lump sums of money, or let's say a hedge fund operator, they receive a large distribution through their hedge fund or from a movie studio or a record label, whatever. So those funds will go directly into the trust, and the trustee will then distribute those funds. So the trust agreement will designate the trust most likely as irrevocable. So that means that basically the owner of the trust does not have the power to terminate it. So what this does is it isolates the owner, the beneficiary, from creditors. So if anybody sues that person, they cannot get to that money. And furthermore, that money is not considered a part of their estate, and it is not taxed until the distributions are made. So those are multi-layer benefits. Okay, so their tax bracket is kept at a lower level. Okay, so the next item is what can be held in a trust, and can you mix assets within a trust? So let's say, can a trust hold money in a bank account, multiple bank accounts, and property together, let's say airplane or homes or a single home or cars? So generally that should not be mixed. Okay, those assets should not be mixed. A trust with significant cash should not also hold title to a home or multiple homes. So obviously business assets such as vehicles or investment property or commercial airlines, air transportation, helicopters are not going to be put into a trust. Those should be in LLCs or other entities, probably LLCs, most likely. But personal assets need to be segregated the same way as business assets should be segregated. So you would want to put your personal home, if there is no full homestead exemption in whatever state a person is in, then they would want that home in a trust. It's their own personal residence in a trust. They would want the larger account in a trust. And so wealthier people will have multiple trusts. And some may be revocable, some may be discretionary, some may be non-discretionary. They'll just mix and match, but they will not put all their assets into a single pile. Okay, so that's very important to remember. So if one trust is attacked and for whatever reason, let's say a family member contests the trust and challenges the trust that is established by somebody else, and the trust has to be liquidated, then there are other trusts and other assets that may be used to maintain the lifestyle of that specific beneficiary. So these things do happen. There's a lot of litigation with trusts. They're challenged regularly. And so the point is to make a strong trust document, to make it irrevocable. Okay, so just like a dynasty trust, for example, will be irrevocable. Dynasty trusts are new creations that are meant to span multiple generations, and there's a limited amount that can be placed in them, about 11 million at this point, and they are irrevocable. They cannot be terminated. They cannot be the terms cannot be changed, and the beneficiaries cannot ever change the terms, and they will receive a fixed amount per the discretion of the trustee, per the terms of the trust. So that's a dynasty trust, okay? So usually most people don't really get involved in that. So I think that should limit what I have to say about trusts. Remember, they are excellent vehicles to segregate your personal assets from yourself and isolate yourself from various creditors, such as financial creditors and even potentially ex-spouses or future ex-spouses. Trusts may be offshore. That is a whole other field. Offshore trusts do provide the best asset protection, and they are relatively easy to form, and their trust terms will usually direct the trustee to terminate, liquidate the trust, and relocate its situs to another jurisdiction in the event it's attacked. This is easily done, so generally that type of trust becomes unassailable. While in the US, generally you can't do that. There's a full faith and credit situation where if you get a judgment in one state, then you can enforce it in any state where a trust is moved. So in other countries, such as the Caribbean, for example, they do not recognize American judgments, and so the person going after a particular trust would need to get a judgment in every jurisdiction where the trust is moved. So it makes it infinitely more expensive and complicated to get a judgment against an offshore trust. So that's why offshore trusts are generally the best option if there are significant assets that need to be shielded. But there's the issue with the trustees. The trustee has to be extremely reputable because you are really giving up control of your funds to this trustee. They have to be well established, very old, and have a fantastic reputation in the industry. So this is sometimes a little bit difficult to find at reasonable rates because you don't want the body of the trust being eaten by the costs of the management for the trustee. So we'll get into offshore trusts at a later date in more detail and talk about some provisions that should be in the trust agreement to protect that trust. But remember, wills are also fantastic documents, and also many trusts will include what is called a pour-over will. So once a trust is funded, it is active, but if a person passes on, then a revocable trust, if they have a revocable trust, will become generally non-revocable. And if it is not fully funded with all the property of that individual, then that property needs to be probated. So that is why a pour-over will is used to quickly and easily probate. And then once they get the testamentary letters, the administrator, the executor actually, then the property that was not moved to the trust previously can easily be moved into the trust, and the trustee will take it from there and distribute it according to the trust agreement. So generally it's pretty difficult to really move every single asset of property that the settlor, the owner, will have. So generally pour-over wills are pretty common. So okay, that should cover the basics of how trusts are used to protect an individual's assets. Let me know if you have any questions. Subscribe. Thank you for watching. Be cool.